Okay, does that indicate that it's recording on your screen?
Yep, all good to go.
Okay, excellent. All right, welcome everyone to this, our third Justice Talks event for 2021. My name is Jane Wangman. I'm the Faculty Co-Director of the Brennan Justice and Leadership Program, and I'm joined this evening by my law student co-directors, Georgina Hedge and Mac Middleton, and I'm also joined by Crystal McLaughlin, our Program Administrator. So welcome all. Welcome to our Dean, Professor Leslie Hitchens, other staff members, alumni, and all our Brennan students. And I'd particularly like to offer a very warm welcome to our two guest speakers, Professor Fleur Johns from the University of New South Wales and Associate Professor Karen O'Connell from UTS. Before we begin tonight's event, I'd like to invite Georgina Hedge, one of my co-directors, to provide the acknowledgement of country.
Thanks, Jane. So before we commence tonight's event, I would like to acknowledge the Wangal people of the Eora Nation, upon whose ancestral lands I am zooming in from tonight. I would also like to pay respect to the Gadigal people of the Eora Nation, upon whose ancestral lands our city campus now stands, and to any other Indigenous lands you may be zooming in from tonight. I would also like to pay respect to the elders both past and present, acknowledging them as the traditional custodians for this land. I extend a very warm welcome to any Aboriginal and Torres Strait Islander people who are present with us this evening. In light of the content of our talk tonight, it is important to acknowledge that from the beginning of colonisation and continuing to the present day, Indigenous Australians have never been afforded the protections promised by the rule of law. We encourage students to consider the themes discussed in tonight's talk in relation to the barriers Aboriginal and Torres Strait Islander people continue to face in relation to the rule of law.
Thank you, Georgina. I also pay my respects to the traditional owners of the land on which I'm coming to you from this evening, which is the Gadigal people of the Eora Nation. So it's really fabulous to see so many people interested in attending tonight and actually coming along. Rule of law was very much in the news in March when there were allegations where former Attorney General Christian Porter faced allegations of sexual assault. And it's great to see that this is a continuing interest continuing interest to so many of our student community, with you all coming along this evening. So before we actually get into talking about it, there's just a couple of housekeeping matters that I'd like to deal with first. And I'm sure by this stage of the pandemic, you're all quite well versed in how Zoom operates, but please remember to keep yourself on mute if you're not speaking. If your bandwidth allows, it would be really great if you could have your camera on, particularly when you're asking a question. This does make it feel like a more interactive event. It's great for the speakers to see some friendly faces, but only do so if you really feel comfortable doing so. If you do have your camera on and you find that it's starting to freeze a bit, you can just turn your camera off and it should free up some bandwidth for you. Finally, for those students who are participating in the Brennan program, in order to get your 5 ROJ points, please just list your full name as it appears in our UTS systems in the chat box, and our Brennan team will award you your points after the event. So as I said, back in March, rule of law was raised by multiple commentators, including Porter himself and the Prime Minister, and a wide variety of legal and non-legal commentators. These comments were made in a wide variety of different forums, so press conferences, newspaper articles, opinion pieces, blogs, and social media. In the advertising for this event, you had this diagram, which I've now reproduced on this slide, and it tries to capture some of the variation about the way in which people were talking about rule of law, what they thought it meant, how they were invoking it, and what kind of legal or political context. On the 6th of April this year, Chief Justice Tom Bathurst of the Supreme Court of New South Wales gave a speech to the New South Wales District Court Annual Conference, and he also spoke about rule of law. I'm going to quote a couple of passages from his speech because I think it kind of captures the impetus for this event. So he said, "I have been troubled by the discourse around the rule of law playing out amongst politicians, the media and the public. What has become clear to me is that there are profound misunderstandings about what the rule of law actually is and about the practical consequences of living in a society underpinned by a belief in the rule of law. Upholding the rule of law has become the argument invoked to justify a range of divergent positions on current issues. What we find then is that one of our current challenges to the rule of law is a lack of public understanding as to what it really means. We must remember that the rule of law is such a powerful rhetorical weapon, both in legal and political argument, that care is needed in its deployment." So it was in this context of these mixed discussions and the need for informed ones The two pieces sparked my interest in bringing together speakers who could engage in some of these complex discussions. The first was a piece by Professor Fleur Johns and Martin Greer in the Monthly magazine, and the second was a piece by Karen O'Connell with Liam Elphick from Monash that was published in The Guardian. And so this is tonight's event. This Justice Talk event is slightly different to the format for some of our previous ones. Both Fleur and Karen will speak briefly to the concerns that they have raised in their pieces, after which we will open the floor to questions. You are very welcome to post questions in the chat box as people are talking, which will be monitored by Georgina Hedge, one of my co-directors, or you can ask questions live over Zoom in the question time. And we actually do really encourage you to do so, because the main intention of this Justice Talk event is to have this kind of interactive, informal discussion. So that's enough of me talking. So now it's my pleasure to introduce our first speaker. So our first speaker is Professor Fleur Johns from the Faculty of Law and Justice at the University of New South Wales. She works in the areas of public international law, legal theory, law and development, law and society or socio-legal studies, and law and technology. Fleur studies emergent patterns of governance on the global plane and their social, political and economic implications, employing an interdisciplinary approach that draws on the social sciences and humanities and combines the study of public and private law. Welcome, Fleur.
Thank you so much, and thank you to you and to Crystal and Georgina and Mac, and of course to Karen for the invitation and the opportunity to have this conversation. I'm really looking forward to particularly the question and answer around this, because yeah, lots to say. But let me briefly open by just restating for the benefit of those who haven't had a chance to read the piece in the Monthly, something of what Martin Krieger and I were arguing, and I'll just remind everyone of the kind of moment that we were speaking to. And I should say Martin Krieger, with whom I wrote this piece, is someone who has thought about and written about the rule of law for almost his whole academic life. So if you are interested in the subject, I would definitely commend his writings on this for a much juicier and more sustained engagement with the topic. But as you know, as law students, the rule of law is a tremendously nebulous, but nonetheless meaningful concept, something that can sometimes seem a bit apple pie-ish. So it was kind of interesting to see it become so charged and conflict-riddled at this moment. As you know, also, there's an immense amount of investment in this concept in legal and political argument, and vast amounts of money invested around the world in so-called rule of law programs that cover all sorts of things like police training, judicial training, constitutional and legal reform. So it's a really material concept that does a lot of work and moves a lot of resources in the world. But it is nonetheless, I think, Martin, I would agree with Martin in his work when he talks about it as an ideal that's really always imperfectly realised in practice. And that ideal is, we argued, basically concerned with tempering arbitrary power and with keeping at bay possible alternatives to the rule of law, namely the rule of people, that is the particular people who happen to be in power at a particular time, and their whims or beliefs or opinions or biases, or a rule of faith. It's a secular concept as well. So the rule of law is concerned with opposing and keeping at bay those alternative forms of rule or authority. So it implies subjection to a set of secular institutions and procedures that are known to all and operative in a broadly, roughly predictable and consistent way. So as you know, just recapping the basics, all sorts of rules and institutional design features can be traceable to the rule of law and to rule of law concerns, which is why it was strange to see, given this very specific content by the Prime Minister. But it's commonly taken to encompass equality for all before the law, the independence and the accessibility of laws and legal processes, and the protection of certain individual rights and liberties, including the right not to be punished except by due process of law, which in turn encompasses notions like the presumption of innocence and the right to information about the allegations that one is called to answer. So remembering, as Jane has, that moment when everyone seemed to be talking about the rule of law, particularly the Prime Minister, in this very defensive way, arguing that to subject Christian Porter, the former Attorney General, or the allegations against Christian Porter to any kind of inquiry or investigation other than a police investigation would be in violation of the rule of law, it was said, because it would subject him to some special additional process or more stringent second layer of scrutiny beyond what most people would ordinarily be subject to. That was more or less the argument, and thereby roll back his presumption of innocence. And Martin and I argued, feeling quite riled up about this, that it was exactly the opposite. That in fact it would be, not only was it incorrect to view the rule of law as requiring allegations that could potentially found criminal liability to proceed along this singular path and no other path, not only was that incorrect in ways that we point out in the piece and that Karen also alludes to, given that people are very routinely called to answer allegations that could potentially found criminal liability under workplace investigations, occupational health and safety, Human Rights Commission conciliation, licensing and professional standards boards, all sorts of bodies commonly deal with allegations that could potentially found criminal liability and deal with them in ways that are designed to be protective of individual rights and liabilities, often, although albeit under a different standard of proof to the criminal standard of proof. So everyone else is subject to these multiple routes potentially subject to these multiple routes of investigation and inquiry. And so we argued that not only was it incorrect to say that there was this single route, but it would actually be inconsistent with the rule of law to insulate Christian Porter from any additional inquiry, simply by reason of the fact that the police route was foreclosed for reasons beyond anyone's control. The fact that the complainant or the alleged victim was dead and a full statement had not been given before her tragic death. And that it would be therefore inconsistent with the rule of law to exercise an arbitrary protective power to insulate him from any additional investigation merely because the Prime Minister believed his allegations or because he had been subject to undoubtedly distressing coverage in the media. And that we argued would be the arbitrary exercise of, or that would constitute an arbitrary exercise of power, precisely of the kind that the rule of law is designed to counter. And it would be inconsistent also with the routine expectation that people who have great power over others, such as an Attorney General, or indeed any legal professional, be held to slightly higher standards than most people, as we are as lawyers before professional standards boards. So there were two aspects to that. It would be arbitrary, but also it would be inconsistent with the expectation that people in those particular positions be demonstrated to be fit and proper in order to ensure that the public confidence in this case, the legal system, but in other cases, say the health system, for when you're talking about medical professionals, be retained. And in the piece, we also mention pending changes to the Migration and Citizenship Legislation Amendment, the Migration and Citizenship Legislation Amendment Bill as an example of a current piece of legislation in relation to which rule of law concerns were being raised, which we saw as a really powerful counterpoint and an illustration of a very genuine and serious rule of law concern being raised by the government's actions. In that case, the prospect of people whose visas might be cancelled or passports might be withdrawn, not having access to information about the basis for the decisions against them. So the paradox was the government was championing the rule of law in one instance and then very clearly threatening it in a second at the same time. So that was the cause of our anger. I'd really be interested to hear among any reactions, but also what you think the public understands of the rule of law. And also what your reactions were to its mobilisation in these ways. But that's enough from me now. I'd like to hear more from you and also from Karen.
Thanks so much, Fleur. That was a really good capture of some of the tensions and, I guess, differing positions that were coming through at the time. And I found the migration example really powerful in your piece of work. Anyhow, now we're going to keep the questions all to the end. So now I'm going to introduce our second speaker, who is Karen O'Connell. She's an associate professor from the Faculty of Law here at UTS. Karen is an expert in discrimination law, particularly sex and disability discrimination, sexual harassment and gender equality. She has worked for over 20 years on equality law and policy reform and advises public and private organisations on equality issues. Her current research is on intersectional sexual harassment and gender inequality as a public health issue. Welcome, Karen.
Thank you so much, Jane, and thanks to everyone in the Brennan program for the invitation. It's a wonderful opportunity to exercise my thoughts about this again, because like Fleur, I was really frustrated by this debate when it first took place. Liam Elphick, who was my co-author for the Guardian piece that you were given to read, and I are both equality law scholars, as Jane said. And in that role, in that role as equality scholars, we see all the time that great injustices are compatible with a legal system that purports to be based on the rule of law. So we know that the rule of law in itself doesn't provide automatically justice outcomes. And it was very frustrating seeing that, in part because this concept, as Fleur has said, is both ubiquitous but also elusive, it can be used in ways that are have a lot of force and power politically and socially, but in fact look like a misuse of power. So it's ironic that this concept, which is supposed to be all about holding power to account, can actually be used rhetorically for the reverse. So in this case, one of the issues that I found most frustrating was that when the Prime Minister made comments and the former Attorney General made comments about the rule of law, they were talking as if allegations of sexual violence could only be dealt with in the criminal law. And as Fleur has said, that is a very, very narrow understanding of what the full legal system response is or can be to such allegations. So I felt at the time that it was very inadequate that this debate was taking place against a backdrop of a really great injustice, which is the inability of our legal system to deal adequately with gender-based sexual violence. We know that the criminal law is a terrible tool for dealing with sexual violence by the mere the extent of the problem and the very inadequate response of the criminal law in terms of ever really providing remedies to people, or in fact justice to people who have had such experiences. So without acknowledging that, and with that sort of approach at the time of, well, if we can't have a police prosecution here, there's nothing to see, there's nothing to be done, we just have to leave it, also seemed to me to be building towards another injustice, which is a traditional lack of visibility for gender-based harm in our legal system. There's been a long history that these sorts of harms are just not seen and not dealt with. So hearing that rhetoric around and seeing rule of law be used to that end was particularly frustrating. Now, I think that raises another point, which is what the relationship of justice is to the rule of law. For some people, the rule of law is a formalistic thing, and as long as you have certain rules in place, that is the extent of the rule of law. But for others of us, and I would think most people who work in areas that deal with equality and inequality, if you just focus on a framework and not on content, that is how those injustices can be perpetuated. And so that leads me to a kind of third point, which is how we actually get to whether we consider the rule of law to necessarily have a content that addresses justice, or whether having the formalistic rules in itself is enough. And what I would argue there is that if we take an approach to the rule of law where it can just be used as this rhetorical device, it doesn't have to account for historical injustices, and it doesn't have to have a content that deals with social justice. It can actually become a vehicle of injustice rather than what it is traditionally seen as, which is a fundamental pillar of social justice. So what do we do about this? I mean, this is what I'm hoping we can talk about a bit more together. What I would suggest is an approach that I'd really take from feminist legal theory. I don't know if anyone has written it in exactly this way, but over many years of reading it, what I have taken from it are two questions that I always ask myself about such principles. One is, what is this? In this case, the rule of law. What is this embedded in? And what has been left out. Now, Georgina, in her acknowledgement of country, mentioned Indigenous, the injustices done to Indigenous people, and I think we could ask the same question here. But if we consider these two questions, what is the rule of law embedded in Australia? It is still currently embedded in a system that permits the most egregious forms of violence to persist against women without remedying them. And what is left out? It's a tradition where the rule of law developed, and is a tradition that is built out of a legal system that left out women's perspectives and also Indigenous peoples and many other groups. So I think given those two serious injustices, what we need to do is expose the rule of law to discussion, and consider it again and think of it in this contemporary light, and think of it with the people who've been left out at the centre instead of the margins. And that's what I see us doing here today. Thanks.
Thanks so much, Karen. So both you and Fleur have raised so many interesting points, and I really like your call at the end to expose some light on really sort of unpacking what we mean by it and who has been indeed left out, and where the focus has been in some of the discussions around this. So this is actually now our time to open up to really try to enrich some of this discussion. So Georgina is going to facilitate some of the questions. So people, we very much encourage people to ask the questions in person, but I know that many people have already been typing away madly in the chat function, so there's lots of questions there already.
Yeah.
So Georgina, yeah, you might want to start us off.
Amazing. Thank you so much, Jane. So before we get started, I can see, as Jane said, the chat is absolutely flooding with questions, but we might open up the floor in case anyone wants to ask a live Zoom question before we get into just me repeating the questions out of the chat. So if anyone wants to unmute themselves, nothing to be afraid of. I'm sure Fleur and Karen would be happy to answer your questions, and we'd really encourage that.
And we're not scary at all, are we, Fleur?
Is anyone?
I'm happy.
I have a question.
Oh, sorry.
Sorry. You go if you like.
No, you go. I can wait.
Okay, this question was more for Karen. I was just wondering how the civil law system should be equipped to handle sexual assault matters without re-traumatizing the victims, because this is so often the case when these matters go to a criminal trial, something that you alluded to before.
Well, that's a very good question. One thing I want to make very clear when I wrote this article, it was a newspaper piece and very brief. So one thing I couldn't really address fully is the civil law system is also pretty terrible at dealing with sexual violence. I think the one benefit it has is it doesn't have that incredibly onerous burden of proof that the criminal law has, and it doesn't have some of the systemic policing and other, issues, structural issues. So it has some benefits. I don't know that you can have a legal system that guarantees that there is no further trauma for a person bringing a case before it, at least not the legal system that we have now. I think that is a big and a very valid question. I think that, though, that some of those systemic problems and structural problems that exist in the criminal law are just so traumatizing, because we know from the figures that we've got that so few people succeed in, it's obviously cases are not brought by the individual in the criminal law, they're brought by police. But one of the issues there is that when we have someone not found guilty in something like a sexual assault case, that is read as that didn't happen. And I think that where we use the criminal law or even the civil law and read that as a determination of truth, that in itself is a really traumatizing thing. So I think there are so many elements that can be traumatizing in the system that there's no one simple answer to that, I'm afraid.
Thanks, Karen.
I'm happy to go. So my name's Charlotte. I'm a law student at UNS. Oh.
I ask people to put your system on mute if you're not asking a question.
Yeah, I've muted.
Okay. Thanks, Georgina. I don't know how to.
Sorry, Charlotte, keep going.
Oh, that's all right. It happens. So yeah, I'm a student at UTS and I'm also a sexual assault survivor. And everything you're saying about just like what you just said, Karen, about like you can't have a legal system that guarantees no further trauma. You know, that's definitely something me and like I'm not the only survivor in my family, unfortunately. Like that is something every single woman in my family has had to weigh up. Like almost like we try to go to the police for justice and potentially be more traumatized, or do we not get justice but don't get traumatized? So I guess my question is like, what are the options for survivors? Because it feels like a double-edged sword.
Can I answer that one, Jane or Fleur? Did you want to answer? Okay, all right. Thanks, Charlotte. I mean, what I would say first off is that law is just one means of response. One of the things that I think is also really important is having some other form of acknowledgement socially and historically for experiences that people have had. So, you know, there's a lot more interest now in restorative processes, having means of people speaking up, because I think another sort of feminist principle is that you listen to what people are saying they want when you develop your legal your legal avenues and your remedies. And I don't think we've done that with women at all. So in the main area of mine, sexual harassment, women often end up going through procedures that they never had any interest in going through, and is not getting them a remedy that is the remedy they want. So I think that if we could start from scratch, we need to go back to what people are saying they want to remedy their harm and build our responses out of that. We can do that to some limited degree when we do law reform, but it is a bigger picture. What I would like from the kind of Australian public is that acknowledgement that if someone isn't successful in a criminal case or even in a civil case, that is a legal determination of truth. It is not a social or moral determination of truth. And I think that is really important so that people can be listened to and respected, even if their cases don't succeed in law.
Just to add, I guess, just to say something I think that complements what Karen just said. And I'm sorry that you've had that dreadful experience and your family has had that experience, Charlotte. The very things that are designed to temper arbitrary power, the very features of the rule of law that are designed to create the sense that we are subject to a form of authority that is apart from the human, that it's apart from the humans around us, that's somehow systemic and self-sustaining. So the very qualities that are designed to produce that experience, the translation of everything into a standard set of language, the procedural standardization, all these features of the rule of law that have been so central to modernity and to the capitalist system. You know, this is, Max Weber is key to understanding the way in which this has been key to the development of the modern state and the modern economy. So all these features, they have some benefits which can be pointed to historically to temper certain types of power, certain types of excess and abuse of power, but they also come at a very significant cost in terms of the loss that is occasioned by that translation, that standardization, that kind of automaticity. That experience is one of not really being spoken to by another human, but being spoken to or seen by a system. So by its nature, it creates this experience of not being heard in a way, even though it's designed to deliver justice, because it's not meant to be experienced as the voice of a single person actually hearing and speaking to you. So I think, as Karen said, that the system requires continual supplementation by other forms of truth-telling, other forms of knowledge-making, narrative forms, fiction, art, all sorts of other forms of law, including First Nations laws, which have other forms of truth-telling, other forms of administration of justice. We can't just, have this single monopoly because of the very significant costs that are built into the benefits of the system, as it were.
Great, so thank you so much, Karen and Fleur. If anyone else doesn't have a live question, I can move to the chat box. Anyone wants to speak out? No? Okay, well, we're lucky that we have quite a few questions coming in from the chat box, so our discussion doesn't end here. So we had a question from Georgia in the chat that says, how can we say that we have a rule of law in this country when we still have exceptions to sexual discrimination laws which presently render members of parliament, judges, and public servants less accountable than other professions for harassing colleagues in the workplace? So we can open that up to either Fleur or Karen.
You want to take that first, Karen?
Yeah, yes, I will. Well, again, that's an excellent question. The issue there, in our Sex Discrimination Act, our Federal Sex Discrimination Act, we had just quite a narrow definition of what a workplace participant was for the purposes of the Sex Discrimination Act, and therefore sexual harassment as well. So, they were left out in a way almost indirectly. So I'm not sure that there was an intention there, but certainly it's true that what we have seen evidence of this year and last year is that some of the people in our system with the most power are actually the least accountable. And not only that, but we didn't know. I mean, again, that invisible nature of so much of this harm meant that there are so many barriers to people speaking up and being heard that it was hidden for decades, some of these behaviours. So I think that is a very good question. If you've got a system where people in practice aren't held accountable, and where we didn't really know that gap in the law mattered so much because the problem was hidden, then we have a system where people in power actually aren't being held to account.
Fleur, did you want to add anything there, or I can move to the next question?
I couldn't add anything.
Okay, great. So we can move on. And if anyone wants to jump in and ask a live question, please feel free. It's fine to interrupt me. So we had a few good comments. Reese commented that I find it intriguing that the Parliament is hasty to enact law reform that directly implicates the Parliament. And he also commented that we're still waiting 30 years for impactful change in law reform following the Royal Commission into Aboriginal deaths in custody. So that was another good observation from the chat box. So Rafaela had a question. I think this was related to what Karen was talking about, and she asked if you could please elaborate a bit more on the rule of law specifically relating to the Immigration Amendment Bill. I'm not sure if that was from Karen or Fleur, but if we could just cover.
That one's Fleur.
So Fleur, if you wanted to take that. Thank you.
That my colleagues in the Caldor Centre for International Refugee Law have written extensively about. So I would commend their press material and also their submissions on this, which are all available on their website. But my understanding, not being a specialist in the area, is that the legislation, the bill, under the rubric of counter-terrorism, withdraws or doesn't guarantee access to information for people who are facing visa cancellation or withdrawal of passports, withdrawal of citizenship, sorry, on character grounds. So the idea is to preserve because of sort of national security concerns, preserve the state's capacity to withdraw citizenship or cancel visas without disclosing in any form to anyone on the side of the person affected, not to them or their legal representatives, the grounds for doing so. So that creates a situation where the person is facing life-changing changes in their legal status and has no prospect of being able to answer or verify or test the basis for that decision. And so the concerns raised, which are much more rigorous and detailed than I've just summarised there by my colleagues at the Caldor Centre, were really framed around this is a core rule of law concern. This is exactly what we should be arguing about when we argue about the rule of law, that the most vulnerable people in our society, in many cases, obviously people on visas being more vulnerable than those who have permanent legal status, but even people with citizenship being often racialised communities, facing the prospect of these kinds of faceless, informationless, blank decisions that they have no prospect of answering is really inconsistent with any claim to be a system governed by the rule of law. So it wasn't a detailed exposition in the paper, it was really just a contrast to be drawn and a kind of redirection of attention. Let's not worry so much about Christian Porter. Obviously, that we want to ensure that he has access to information, has legal defence and so forth in any proceeding or investigation to which he is subject, but he's hardly the most vulnerable member of society.
Yeah, thank you, Fleur. And I think that leads nicely on to another question that Rafaela had, where she asked, can the rule of law actually be enforced for members of parliament? And she clarified this by saying, as we can see that there is an implicit breach of rule of law by people like Christian Porter, is there a way for this to be dealt with legally?
Well, I teach constitutional law, and for those of you who have already done constitutional law, you'll see, you know, our system is based fundamentally on the idea that we can vote people out. I mean, it's really that idea of, you know, representative government and also responsible government, where ministers are answerable to Parliament, and then Parliament is answerable to the people, means that we are supposed to have the ultimate power to vote people in or out. I have never found that satisfying when I talk to my students and teach it, for so many reasons, but let me just give a couple. It assumes that a single issue, however egregious and you know, problematic it might be for you at that time, is then going to be the basis of you voting years later. It also assumes that you have a full choice, a range of views that you can choose between, which we know is not true in what's effectively a two-party system, where views can be very similar. And certainly the two parties we have both really carried out some fairly appalling practices, human rights practices in relation to asylum seekers, to give one example. So that is what is supposed to be ultimately the protection against abuse of power for members of Parliament, that they exist there just at our with our authority. But of course, in practice, I think that is a very blunt tool to respond to issues in a political cycle.
Amazing. So we've got a question from Shira, who asked, what happens to the rule of law in cases of ministerial intervention or discretion when the ministers refuse to intervene or exercise discretion, doesn't that give the minister so much power without checks and balances that they are really above the law? So whoever wants to take the floor for that one, maybe Fleur, if you wanted to comment.
Yeah, well, I mean, in general terms, I guess we look to administrative law to regulate that kind of power. But of course, that doesn't eliminate or cabin all forms of discretion within the law. I would argue that discretion is ubiquitous within the legal system, that there's always political decision-making going on in every form of exercise of legal authority. So the rule of law doesn't eliminate, doesn't even aspire to really eliminate discretion. What it does is kind of force discretion. That's why I like Martin's use of the word temper. It alloys discretion or alloys political choice with these particular sets of procedures and rituals and institutional practices, which give us ideally the opportunity to confront or challenge or question. So we would typically, in that instance, look to administrative law under certain circumstances to challenge either an exercise of discretion or a failure to exercise discretion where administrative law requires it. Of course, that doesn't mean that all instances it would be the type of scenario you're describing could be litigated or even questioned on administrative law grounds, but it's really that alloying or the channeling of discretion through rituals or practices or institutions which are designed to present at least the possibility of confronting it with an alternative view or a question or a challenge, which is characteristic of the rule of law rather than the elimination of discretion.
Great, thank you so much, Fleur. So that works well because now we have a specific question for Karen from Ella. Do you think expanding sexual harassment claims through the Sex Discrimination Act as proposed by the Morrison government is the best way forward? Or do you think we should be broadening the tort of battery and assault to capture this?
Well, I don't think it's the best way forward, but I also think that expanding the tort probably also isn't the way forward. This raises another question about the rule of law as well, which is it about protecting individuals? Often the rule of law is raised where there has been arguably an injustice, maybe a procedural injustice for an individual. And I would argue that if we want justice to be done, we need to think much more collectively than our legal system generally does. So if we want to prevent sexual harassment and other kinds of gendered harms, I think we need to look at things much more broadly and as a group experience. However much you strengthen individual actions under the Sex Discrimination Act, it's never going to be enough. It's never going to change things enough. What I argue for instead is what's called positive duties, where there is you actually look at environments or institutions as a whole, and you create an obligation to have a positive environment in those arenas. So the people who have control over those institutions or environments have an obligation to prevent harm within them. To me, regulatory models and positive duty models have got a lot more promise than anything that requires an individual, particularly an individual who is already harmed, possibly already traumatized, to take on a system that is hostile and work their way through it and somehow overcome some of those systemic problems as an individual. I think that's another kind of harm then on that person. And it's to me, it's never going to solve these really broad issues and problems.
Thank you so much. So our next question is a bit more general from Kamini. She asks, would it be fair to say that the problem isn't actually the law itself, but rather the people who administer or don't administer it? So I think both Fleur and Karen could speak to this one.
Maybe I'll start. It's a really interesting question because it kind of performs an experience of living under a rule of law, because that's exactly the kind of experience that we're meant to have in a rule of law system, which is that the system is somehow durable, and any problems with it should be rectified by reforming and working on the system. But somehow the system as a whole is beyond question. So when it doesn't work or when it's unjust, it's because it's been improperly mobilized in a particular instance, or there's been some perversion of it by particular people within a system. And lots of institutions work on this sort of logic. And it's not inherently bad. I mean, in fact, there are lots of reasons why we might think that's really valuable, as I was trying to suggest earlier, preferable to other forms of authority or other forms of rule that it's designed to counter. There's something very powerful about a diffuse collective investment in this collective work product that is this system that's defensive of the rule of law. But there is a big problem with that style of thinking, which is that it directs us towards continually tinkering around the edges, or focusing on the individual instances of bad behaviour or injustice as perversions, as problems that are incidental to the whole system. Somehow the system itself is beyond question. And so it has a kind of conservative effect, which is that the status quo needs to remain in place, and we can only ever just tinker around the system. And the problem is, we know from all sorts of experiences throughout history that large institutions can become manifestly unjust in all sorts of, like, we can think of these large institutions that propagated the conquest of First Nations land and the stolen generation and so forth. These large institutions which were well-meaning and for their purposes well-designed, and yet propagated incredible violence and devastation, which people live with today. So I think there's a problem with saying it's only ever the particular people administering the rule of law at the relevant time that are at fault. I think we need to keep alive the prospect that there is something central to the whole system that is also worthy of questioning and working on, and that systems do and have changed in really dramatic ways. We do and have redesigned systems from the ground up, and that should still be on the table, even at this moment. That we can't just say, because this has been something we've worked on for a long time and we've lived with for many centuries, and it's done a lot of good, that we can't challenge the overall system. I think that is a problem.
That's really interesting, Fleur. And I just want to pick up Fleur's talking about a system, because I think when we talk about a system, it's interesting to think about what we mean by that. And what I would invite law students to do, because I think we still tend to think of law as a thing. So even when we're talking about it as a system, we often think of it as some sort of system that is a kind of entity in its own. And I would just invite you to think about it as an ecosystem that we are living in, so that when we change elements of it, we are also impacting on it ourselves. You know, every element is interconnected. So we can't just find, say, the perfect law and then have a direct outcome, because it is all filtered through every other element that's in that ecosystem. So to me, it's not about just a problem with the law, and it's not just a problem with the people who administer it, but those are two elements within an ecosystem. As someone who works in law reform a lot, I am often trying to think of how you could word a law to have a particular outcome. But you can look at sections that are written in some of the laws that I work most closely with, and I couldn't think of a better way to write them, except that they just don't work. You just cannot get them to be applied, and you cannot get them to work within the system. So in that case, the problem isn't the law, it's some other element. And I just think there's no way around thinking of all of these elements as operating on each other and influencing each other. It makes it much more complex to achieve social justice and to think about how you use law reform for that. But I wouldn't say that means it's not possible at all. It just means it's more complex, and you will never just argue for, say, oh, let's change this law to say X, and be guaranteed of a particular outcome.
Amazing. Thank you so much. So I think we might have time for like a couple more questions. So Georgia asks, do you believe that the rule of law is better upheld under an inquisitorial or adversarial system of trial?
Fleur, I'm going to let you answer that one.
Yeah, well, I've never lived large swathes of my life under a civil law system, in a civil law system. So I'm definitely more familiar with the adversarial system, but I certainly don't have the view that a civil law system or more inquisitorial system is in itself somehow inferior or less able to deliver on the ideal or aspire to deliver on the ideal of the rule of law than an adversarial system. And it's interesting to look at I don't know if anyone's read I teach the cases around the extradition of Julian Assange and the way in which the British courts were kind of horrified by certain aspects of the Swedish criminal justice system in ways that seemed very parochial and sort of very much the distrust of the civil law system and the more investigative inquisitorial system was really manifest in the British courts in that instance. And so it's interesting to think of how we react to that which with which we're less familiar, tending to be suspicious, when perhaps we should be equally suspicious of our own system.
Great. So I think we've got one last question, which might be a nice way to wrap off our question portion, is from Rafaela. And she asks, is there any literature that you would recommend that discusses the theory and practicality of the rule of law? Apart from both of your great articles, is there anything else that you would recommend?
Fleur, does anything come immediately to mind for you? Because I can think of 100 and none.
I mean, there's so many. And a lot of what I have engaged with and read is concerned actually with a different context to this one, not really with Australian law, but more around the development context and the kind of struggles that occur when countries deliver aid under the rubric of improving the rule of law in another system, which is, you know, always fraught and difficult. But I would commend Martin Kriegier's writing, and maybe I'll follow up with a particular piece in which he kind of restates some things. He's obviously written lots and lots on this, but there's one particular essay that I think might be a nice encapsulation of some of his ideas. He's worked through these in the context of coming to terms with the post-communist transition in Eastern Europe. So his work is very much informed by the empirical experience of transitioning from communist power to a democratic system and thinking about what that entails and how that might be achieved. Obviously, he doesn't suggest that it has been achieved with any perfection, but it is empirically and historically grounded. So it's interesting in that respect that it's a contemplation at the level of theory that is very much informed by that historical experience. So maybe I'll follow up with an email I'll send it to Jane and Georgina and Mac and Crystal, and maybe it could be circulated afterwards.
Yes, and I would add there too that my thinking about the rule of law has been more or less in opposition to what I've read about it rather than in harmony with it. So for that reason, I don't really want to recommend the pieces that I've formed my opinions in relation to. But being an equality scholar has very much shaped some of my critique of the rule of law, and that is looking at substance over form, looking at what the outcome of something is rather than what the process is, and looking at the collective over the individual, because those choices all take you in a very different direction than traditional philosophy of law, including the kind of thin or formalistic interpretations of the rule of law. And for that, I think I would recommend and commend the scholar Margaret Thornton at ANU, who, like I said, she writes outside of this particular direct field, but very much in terms of those themes. So I would recommend her and a whole lot of other critical philosophy that might be a bit tangential, so I might leave in case, but anyone can let me know if they're interested. And also you can do my discrimination law subject, and then you'll get all the readings in class. That's my advantage over Fleur.
One other thing I was thinking that are recommending, which it's a kind of reflection on legal education and what happens to our thinking and our politics when we imbibe the values of the rule of law. So that might be interesting. Not everyone will love it because it comes from a particular political tradition, but everyone will react to it. It's an old shortish piece called Legal Education, the Reproduction of Hierarchy by Duncan Kennedy. I'll send that around as well, because it does encourage you to kind of think about yourselves as law students, what you gain and what you lose when you learn to speak and think and work in a legal mode, in a mode that defends and upholds the rule of law. Obviously, there's lots of great things about that, but there's also some things to think about critically.
That sounds great, Fleur.
Okay, so I think that'll wrap up our question portion. Thanks so much to everyone who asked both a live and a chat question. That sustained us for such a long time, so that was really, really great. So I might pass back quickly to James before I give the formal vote of thanks.
So I'm just going to give you an informal vote of thanks. I'd really like to thank Fleur and Karen for such a rich discussion. You really picked up on so many themes, and I know that the students have been either talking about in class. So I teach first year, and we've had some rich, so there is that notion that sometimes we talk about rule of law as though it's very simple. And yet when you start to unpack it, one, there's so many differences of opinion, but it's also so nebulous. And I think you really captured those and its interactions with the people that act it out and the systems in which it's embedded, and made us really think about its historical context. So thank you very much.
Yeah, and I'll just echo Jane. So on behalf of the UTS Faculty of Law, the UTS Law Student Society, and all the students here tonight, I would like to thank both Professor Fleur Johns and Associate Professor Karen O'Connell for sharing their knowledge and comments with us tonight. In light of all the debate about this topic that we've covered tonight, this discussion was extremely timely and really important in the current context. So we thank you both for providing your invaluable insights and facilitating this great discussion. So thank you both again. And thank you to Jane, Mac, Crystal, and Erica as well for your help tonight.
Thank you, Georgina, for your help.
So before we head off, we'd encourage all of our Brennan members. Crystal is going to launch a little poll because we would love to hear from you guys as to what you want to hear from us in future Justice Talks. And we would love to have some more that are like this format or any other format. So we've launched a little poll. So if you wanted to vote in that, we'd love to get your ideas on what we are going to have in our next few series of Justice Talks for this semester and also the spring session as well. So I'll give everyone a little bit of time to do that. And while you do that, I'll just remind all of our Brennan members that you'll receive 5 ROJ for the Brennan program by attending this event. If you haven't put your student number and name in the chat, please do so. I'd really encourage you also to keep an eye out for our current Westmead Arts and Crafts Drive, which commences next week, the 26th to the 30th of April. Please reach out to Mac if you have any questions about that. And we'll also be having our upcoming Refugee and Asylum Seeker Awareness Week events in May. Please keep an eye out for the Facebook event on our UTS LSS Facebook page. That'll be coming out soon. So encourage everyone, pop anything that you would want to hear in the chat. And thank you again to everyone for coming tonight.
Thank you so much for having me. It was great. And it's great to learn about this program, which is and thanks again for the hospitality.
Yeah, thanks from me too. And it was great to talk alongside Fleur. I'm so interested in her work, and also just to hear all the fantastic input from the students. It's very inspiring.
Thank you, everyone.
Okay.
Yeah, thank you both of you for giving up your time and everything. And it really did work well together. So thanks so much.
That's a pleasure, Jane. Bye, everyone.
Bye. Thank you, Karen.
And everyone. Bye. Thanks for voting too. Bye. See you at the next event.
That I mentioned, Jane, in case it's useful.
Sorry, what was that, Fleur?
I'll send you that essay. I'll send you those 2 pieces that I